So welcome back to another episode of Money and Medicine. Today we're going to run a special episode in partnership with IndemniMed, a brokerage exclusive for medical doctors in medical malpractice. And we've got special guests from Genoa here right up next. So MJ, welcome. Thank you so much for joining us today. Maybe just a brief introduction for you, your team, and maybe just the start of Genoa.
Absolutely, guys. First of all, thanks very much for the opportunity to be joining you here today. Genoa Underwriting Managers is a focused liability specialist UMA underwriting management agency. What that means in very, very simple terms is that we focus on all professional indemnity disciplines as well as medical malpractice. I'm joined today by Inge Sieberhagen. Inge is the head of internal Genoa claims, and she's going to be addressing us on a whole bunch of different topics as we move through the podcast.
So maybe either one of you, maybe a brief introduction, and Audrey, you're welcome to jump in here as well. What is medical malpractice? I'm a medical doctor, I'm in government, and I now need to start looking at locum work in the private space. I hear a lot of people asking me, listen, do you have medical malpractice in place? What does that mean? What is medical malpractice? When is it required, etc.?
Yeah, so Stefan, I think for me, what I like doing is I like to give examples, events that can take place within MedMal. I think misdiagnosis is an example, surgical error, medication mistakes, failure to obtain informed consent, delayed treatment, lack of monitoring or follow-ups, failing to offer your services within the scope, your professional scope. From a physiotherapist to a specialist. There's certain medical scope, a standard of work you need to deliver. And if you fail within that, that can lead to a possible medical malpractice claim.
There's a standard of care that needs to be followed by these doctors and by these practitioners. Mistakes happen. So even if you follow the ordinary standard of care, mistakes still may happen, and that may not constitute a legitimate medical malpractice claim against you. So the doctors, that they are held to this incredibly high standard of care, but with that said, the areas that they operate in are often incredibly specialist and incredibly complex and are taking place in environments that are incredibly high stress. So the mistakes do happen. But I think the key point you have for me is that when that mistake happens, it is not necessarily that they have messed up or that they have made a mistake, because they are compared against their colleagues within the industry. And would a person of similar skill, due care, in your position have made the same error?
So on that note, Stefan, I 100% agree with that. In fact, we had a scenario recently, and it was this would be advice that I would give to doctors, is when something happens, when there's an intent to possibly have a claim against you, don't, out of goodwill or in a form of compassion, acknowledge any guilt. There's procedures in place to investigate if there was actually negligence. We've had a scenario where the doctor, out of goodwill, compassion, great human being, went and acknowledged, settled the penalty, and eventually later the patient or the victim, came back with a larger claim. And now there's uncertainty as if the insurer is going to entertain this claim, because the doctor, out of pure goodwill, felt, let me just associate with this patient, goodwill, compassion. So I agree with MJ 100%. It's not necessarily, even though there is this cover, it's broad. If there's an error, it doesn't mean it's negligence. Let the procedure follow.
Okay, so just to summarize what you guys are saying, it's a type of cover specifically in the private space. There's obviously solutions in the government space which we can maybe also unpack. In the private space, that covers you for medical negligence, malpractice, whether you're guilty or not. Obviously, if you're not guilty and a patient feels that there might have been a mistake, there can still be a claim submitted against you.
And defense costs, of course, because we have to represent the interest of the doctor to prove that he or she perhaps hasn't made the mistake that's being alleged that they made.
So that's exactly my next question, is like, what does the cover look like? If that question makes sense. Like, let's say I'm paying whatever amount towards cover. What does that look like? What does medical malpractice look like? What's the type of services that you offer? What's the type of coverage that you do get?
Yeah, so obviously you'll get your main insured amount. And then there's subsections, extensions on that policy where defense cost comes into play, etc., etc. And I think that's one thing I personally like about Genoa's policy document. It's printed out clearly. It clearly stipulates what the extensions are, what is included and what's not included. So yeah, that's one of the extensions the doctor then would benefit from in terms of defense costs. So yeah.
Yeah, on the defense costs in the Genoa product, which is a nice one when compared against some of the competitors in the market, is that our defense costs are not limited. So they go all the way up to the limit of indemnity. There are certain providers in the market that will restrict your defense costs that you have available to you. From our perspective, we believe that throwing the book at potential vexatious litigation is incredibly important to our clients, because there are, unfortunately, in this day and age, a large number of vexatious claims that come against attorneys or come from attorneys to our practitioners. So for that reason, we haven't, well, it's one of the reasons, but we haven't limited the defense costs that are applicable. So our doctors can rest assured that they have a large level of indemnification that will apply to defending their interests.
MJ, just to add on to your aspect on the indemnification and the large coverage that we have due to our legal defense costs not being limited, practically, you see the number on the page, but I mean, I speak to these practitioners on a daily basis. I get those calls from the doctor, they have the patient right in front of an upset family member because their wife or husband or kid just passed away. And from my experience, we are much more than just the legal defense costs. We provide that value-added service. We are there every step of the way with the medical practitioner. We guide them through those conversations, those difficult meetings they have with their patients. And often that mitigation goes so much further, and we avoid either HPCSA complaint or going to court, and matters can be settled in an informal setting to the benefit of the insured as well.
Okay.
Yeah, so I mean, just adding to that point, I think that in this common day and age, the ability of a doctor to show empathy, as was mentioned earlier, it's very, very important. The patient or the patient's family member is often going through an incredibly stressful time. So we do coaching for practitioners in terms of how you can still show empathy in that moment. I'm sorry that you're going through this. That is a very, very important way to show empathy, but not to admit liability and confirm that, in fact, that you have or have not made a mistake. It's coaching like that that's imperative to these doctors to understand the sort of minefield that they have to tread where emotions are running high.
So for some of the listeners that's in the government space,
Yeah.
okay, maybe as a consultant, a consultant does some private work as well, but let's say as an MO, all right, or as a reg, what type of coverage is available in the market, and what type of offering does Genoa offer in that space?
Okay, so amazing. So as you correctly point out, there's a large distinction that's drawn between private and state work. When someone is employed by state, the state is automatically vicariously liable for the errors and omissions that potential practitioner working in state will make. What that means in very simple terms is that any liability that attaches as a result of the actions of that practitioner in state, that's the state is responsible to indemnify them for those errors. There are, however, exceptions to that rule. Some of those exceptions include a practitioner in state who's operating under the influence of alcohol, some form of narcotics. If you disobey the direct instructions of a superior, then you can be seen to the state can argue that they are not vicariously liable for your actions, in which case those practitioners could be up a creek without a paddle. So in my opinion, and Genoa has created the solution for medical practitioners in state, you often need a level of legal representation whilst in state. That legal representation will deal with elements of how do you deal with a situation where perhaps that example that I've raised is brought up? What to do when faced with a claim? Unfortunately, state is not in the position that it was perhaps 20 or 30 years ago. And by that, I mean that it is often, unfortunately, under-resourced. So your superior who something's gone wrong in a procedure your superior is not in his or her rooms. What do you do if someone is now dead on the operating table? So Genoa has put together our state product for practitioners. It's a free product which gives you access to our in-house attorneys. They will assist you with what to do when faced with a claim. They'll assist you with various advice elements in terms of the situation that you're going through. We know that can be particularly traumatic in some instances. So the product includes access to free, I think it's 5 free sessions with a psychologist to deal with the stress and trauma associated with the claim. So essentially what this policy is, and I think it's limited up to about 250,000 rands worth of in-house legal defense costs. The product is there to guide you when you're in this very, very complex environment of state, and you can have access to the big brother who will guide you through a position that you may not be comfortable with. When
you look at what's happening within South Africa currently, there is a large increase in numbers in terms of med mal claims. So me working as indemnity med, especially with the young doctors, offering that free state product from Genoa really gives them a boost of confidence, ease, that should something happen, there is some sort of a support. They do feel vulnerable. And I think that's the big thing with this product, is just to offer some sort of a support and ease.
In terms of Genoa, what is the most typical claim that you guys, it's obviously profession, it's related to the certain occupation, vocation and speciality, but in your space, what is some of the most frequent claims that come through?
Right, so from Genoa's side, the most frequent claims relates to a misdiagnosis, mistreatment, either surgical errors, so you left something like a swab or a surgical instrument inside the patient. Wrong site surgeries are quite prevalent as well.
On that, that's regarded as a sentinel event. It shouldn't be happening in this day and age, and yet Genoa is seeing these claims of this nature, particularly focused around, if I'm not mistaken, the orthopedic environment. We've seen a number of claims from them of wrong side surgery.
Yes, so I think due to the high pressure environment the doctors work in, one thinks it's so basic. You've seen this patient in your office maybe a day or two ago. They signed an informed consent. They explained the procedure to you. You go and you come out and he operated on the right leg instead of the left. But that doctor's probably seen that same injury, 10 times that week.
Okay.
So, there's so much going on. So, it does unfortunately happen.
Yeah.
And then other common claims, anesthesia errors. So that's giving too much medication, too little medication, maybe allergic reactions. Those have come in quite prevalent lately.
Okay.
And then as well, negligent follow-ups or aftercare. So patients, I don't know if it's a new thing, but I'm seeing a lot of claims of unhappy patients that feel that their surgeon is not giving them enough, attention or bedside manner. These surgeons work in high-pressure environments. They see lots of patients on a day. It's not that they don't care. They're actually very good at what they do. Mm. And so I had the claims come in of patients saying they didn't get proper explanations. They felt that the doctor could have treated them better. Medically, everything was sound, but unfortunately the patient is upset because of a lack of communication. That happens quite often as well. I spoke earlier to where Genoa does education, and part of our CPD commitment back to doctors is specifically on this point, but our stats are starting to show that good bedside manner of a practitioner can mitigate a claim. Wow. People are more inclined to potentially litigate against someone who they feel has not shown them the empathy or the due care that they felt that they were deserved. So that good bedside manner of caring and assuring the patient in these trying times. It's a scary thing to be having a triple heart bypass, and if your practitioner is just like, "Oh, I see you still here," those kind of comments are going to get under someone's skin and result in litigation, no doubt. So that good bedside manner is a very, very important element of how these practitioners must interact with their patients.
Yeah. Look, it's a very important point. I think you can't compare clinical experience or clinical expertise to a customer or a patient's experience. But we're also very adamant that as a medical doctor, we live in a day and age where everything is about experience. If you see a medical doctor, gone are the days where you have to wait half an hour, 45 minutes just to see the doctor, and then that doctor is rude, that patient won't come back. There's too many other doctors out there that's actually, focused on patient experience and actually creating a wonderful experience for the person. So also to that point, we 100% in that corner.
Yep.
If there is a claim, so let's say a medical doctor maybe think, listen, I might have messed up. What is the typical procedure? And in terms of time frame, like how long do you have to, obviously I think as soon as possible, but let's just assume this person is a little bit ignorant and just thinking that, listen, okay, no, I'm just maybe overreacting or thinking it might have been a mistake. What is the typical procedure to follow? What would be good advice?
So I'd say phone your broker immediately.
Okay.
Pop them an email, WhatsApp, whatever form of communication you have, because you have different relationship with your broker, and then inform them of this incident. The broker will then contact Genoa, and then we would then ask for further details and provide guidance. So whether it's the patient rocking up with their whole family at your door, or it's a request for records, or it's just someone sitting in your office after a procedure doing a follow-up consultation, seeming angry or upset, those are all circumstances. And I think don't delay, just contact your broker and they can reach out to us.
So even if there's no complaint, you don't have to wait for the patient to react. You can immediately be proactive and say, well, listen, RJ, I think there might be something here.
So in fact, Stefan, that's what I share with my clients. I tell them if there's any idea of a possible claim, any idea that you can just get that there's a claim, immediately inform us. And then we inform Genoa or any of the other insurers, and then that engagement will take place. Sometimes then the insurer's legal team will engage directly with the client. But if we as a broker intermediary need to gather information, we just try and do it as fast as possible. But also my advice to doctors or medical professionals would be immediately inform. Don't delay. We've seen in the past that certain doctors only report later after they've actually found out about a possible claim. And again, there's conditions that you need to comply with in terms of the provision of the policy. If a doctor fails, then there might be consequences. Okay. So our advice is just inform us immediately.
I guess to add to the importance of communication, and MJ, you and Inge can maybe add to this, because I see this quite often, especially a new specialist, in terms of amount of patients seen. Now you work through a proposal form, amount of patients seen, type of procedures done, etc., etc. How long does that doctor have? And again, obviously the question is as soon as possible, but like from a time frame perspective, what would be good advice to update if you're starting to do new procedures or your patient load has just increased dramatically? And because I think very often, again, medical doctors are quite ignorant when it gets to what I'm covered for. They think, I pay a certain amount of premium that should be adequate.
Yep.
Not knowing that, that's actually, misrepresentation of what you're actually doing from a procedure perspective.
Sure. So, I mean, speaking to the vast majority of policies in South Africa, the Genoa policy included, most of them will have clauses around material change to the risk. So naturally, if an orthopedic surgeon is electing to now move into spinal surgery, that requires additional qualifications and then obviously additional rating. That, for example, would be seen as a material change and would necessitate that the underwriter needs to be told. A jump, for example, in the fee income of the practitioner of more than 25 to 30%, that's material. That should be disclosed. So it's basically large-scale changes to your practice that either influence your discipline type, that's essential. Discipline type change, in other words, orthopedic moving into spinal, because that changes your risk to the underwriters substantially. Or alternatively, just large-scale changes where perhaps your operating hours have increased by, again, as a litmus test, more than 25 to 30%. In my experience or in my opinion, those would be notifiable events. With that said, underwriters, they are not necessarily unfair or to the practitioners, but when your practice is changing is sort of the answer. Where I can give you a categoric is in the event that you are aware of a potential matter that will result in a claim, most policy wordings in South Africa give you 30 days in which to notify. So that is your timeline. You have a request for records. You know, well, why are they requesting records? Of course, there's something of a concern. Whilst you're examining a patient after a particular procedure, you as a practitioner pick up something. The patient may not even be aware of it, but if you are aware of it and you are concerned about it, or if one of your colleagues with the same level of skill would be concerned about it, then notify the insurers. It's also why that's also important is because we have the in-house expertise between our medico-legal advisors or alternatively our attorneys who are going to be able to guide you in terms of what you should do. And because we have that in-house expertise, we are best placed to be informing the practitioner how they should proceed. So that's why over-notifying, in our opinion, is often recommended.
Yeah.
So also, Stefan, that's where the intermediary, the broker, is extremely important.
Yeah.
We have a responsibility to share with our doctors that if there's any material change, please do let us know. Because of our direct engagement with the doctor, Genoa won't necessarily request change of material information, because it's our responsibility. So the partnership, the whole synergy between ourselves, doctor and Genoa, is extremely important. But I'm also pro over-inform. Just give me more information.
Okay, so from my earlier comment around notify whenever possible, a lot of practitioners are concerned about notifying because their opinion is that, well, if I notify of a particular adverse event, either my coverage is going to be cancelled or alternatively, I'm going to receive a premium increase. Okay, so underwriters look at a number of different metrics when deciding and looking at that specific query that's been raised there. Number one, we look at the frequency of notifications. Okay, some practitioners notify out of caution, which is encouraged. Other practitioners will be notifying because they are genuinely concerned about the matters that they're bringing to our attention. When it's out of caution, I can't give exact percentages, but when that notification is out of caution, the likelihood of it materializing into a legitimate claim is smaller than when they are notifying out of concern. So we do look at that metric, and often the claim circumstance will dictate whether the practitioner is running a relatively high risk operation or whether it's just a cautious practitioner who is actually someone who we want, because they are completely aware of the types of risks they're looking at. Naturally, it goes without saying that those notifications then either do or do not carry a legitimate legal defense spend. So notifying out of caution, it may not carry any legal defense costs because you've notified of something that you were concerned about but has not necessarily been raised by the patient. When it's raised out of, I've received a request for records, I've received a HPCSA inquiry, I've received a legal defense, I've received a billing inquiry. Those carry physical legal spend where we are representing the interests of the practitioner, and then, like any insurance in the world, you look at the loss ratio of that client. So, how much have we spent versus what is the premium that has been recovered from that practitioner? If that loss ratio starts going out of kilter with their colleagues in the industry, then naturally underwriters will start looking at doing things like a pricing adjustment where the premiums go up, or alternatively an excess adjustment to try and correct that behavior. But again, that's physically evident from the legal spend that we are putting out. If you're notifying out of caution, and I don't want to batter the point, but if you're notifying out of caution, there's not necessarily always going to be legal defense costs associated with that notification. If you're notifying out of necessity, there more than often will be legal defense costs, which then are calculated against the loss ratio of that client. So I hope that answers that one.
Yeah. I think just whilst you guys were talking, and all three of you are welcome to jump in here, one of the most common questions, occurrence-based, claims made, retrospective cover, What does that mean?
The difference between claims-made and occurrence-based policies is possibly the most important consideration for a practitioner who's deciding which coverage in South Africa to take. Right now, all of the South African insurers are offering a claims-made based solution. And there's one provider who operates wide of South Africa who offers an occurrence-based solution. The major differences between claims-made and occurrence, and I'll start with occurrence. An occurrence-based solution essentially implies that you are able to notify the insurer who underwrote that occurrence-based policy for the work done in a particular year or an insurance period, no matter when in the future that claim is lodged against you. So it has an infinite reporting tail. For that benefit, you pay often a highly inflated premium. A claims-made based solution, on the other hand, dictates that the policy has to be in place at the time the claim is lodged against the practitioner. So now, for those on the call who are listening in, they're going to say, but what happens when I retire, when I die, when I cease to practice, I become physically disabled, for example? What happens to me? Because I don't have my claims-made based policy in place anymore. So what the South African insurers have done is we have introduced what's called an extended reporting period, or in Genoa's case, an additional extended reporting period. That allows the practitioners to tailor-make their coverage to ensure that upon retirement, death, ceasing to practice, physical disability, you have an extended time period in which to notify that insurer of claims. Okay, so rather than having an infinite reporting period, the claims-made periods or the claims-made based policies often restrict that to a period of, let's say, 21 years. Why do they restrict it to 21 years? That's often because legal doctrine of prescription dictates that a claim prescribes after a certain period. When you're not dealing with minors or mentally incapacitated people, that prescription period is traditionally 36 months. So doctors who've structured their practice in such a way where they perhaps are not dealing with any of the above, they are able to insulate the practice by ensuring that they only purchase a 36-month extended reporting period, and then they lock in that additional premium saving. However, not all practices are the same. So, for example, when looking at the Genoa policy, we give those practitioners a minimum of 5 years, and then we allow them to purchase year 6, year 7, year 8, year 9 at underwriter's discretion going forward, so that they can tailor-make that policy and lock in those potential savings. The other fundamental difference between an occurrence and a claims-made based solution is that with a claims-made based solution, every policy also receives a retroactive date. That retroactive date is effectively the time period in which that practitioner first took out a policy. And the retroactive date becomes acutely important when a practitioner moves from one claims-made based insurer to another. Because, as I mentioned earlier, with a claims-made solution, your policy has to be in place at the time the claim is lodged. So if I move from insurer A to insurer B, there's a period when I was with insurer A where there was work done that could potentially result in a claim in the future. So when I move to insurer B, I need to ensure that insurer B matches the retroactive date that I had with insurer A. If I don't do that, I'm heavily exposed as a practitioner because insurer B could turn around and say, I'm not responsible for the claim. The good news here is that any claims-made based medical malpractice insurer in the country is willing to offer that retroactive match, meaning that those practitioners are not going to be prejudiced in any way. And that, of course, is the role of the broker to bring to the attention of the clients and the practitioners.
Oh, that's well said. Thank you for explaining that, MJ. I think if one of our listeners, because it's always a sensitive thing, premiums are high, yet it's very intimate and people don't want to sort of water this down when it gets to coverage. What is measures that doctors, simple measures, practical stuff that they can do to either lower their premium or give a more truer, if there's even a word like that, reflection of what the premium ought to be? You know, how can they sort of like just manage premiums what is some of the measures? And I'm talking about like maybe better reporting systems, maybe
Yeah.
going electronic, that sort of stuff. What can they implement?
For sure. So from our side, and again, I'll speak from Genoa's perspective and how we see the risk and what the potential risk mitigants could be there. Doctors that utilize electronic note-taking systems, that is a huge risk mitigant from our perspective. I mean, excuse me, if I say to the listeners today, what did you have for breakfast 3 days ago? Most people are not going to remember. So what did they say to the third patient on a Tuesday after they have had very little sleep because they were up in the operating theatre the night before?
Yeah.
They won't know. So we as an insurance company are best placed to represent your interests and to protect your interests by the notes that you take. So that's why these electronic note-taking systems are a significant risk mitigator. And taking complete patient records ties in with that. So you need to do a detailed history around, I know and we know that time is always tight, but taking a full clinical history of the patient at the times of consultation is imperative to understanding the potential pitfalls and risks that may exist with that patient. A lack of consistency in documentation is often something that we look at. So do you guys follow, or do the practitioners follow a certain protocol? In other words, have they taken the clinical histories? Do they request informed consent? And informed consent, guys, is a massive one. The patient needs to be educated on the potential risks of the procedure that they're about to undertake, and they need to consent to those risks that exist. I mentioned earlier in the talk that communication with patients is key. Often we see doctors will perform what is termed defensive medicine, which means that they will be prescribing too many scans, too many tests and the like, and they're doing that because they're concerned about litigation. Also, what goes with that hand in hand often is that the doctors practice quite a cold communication with the client. They don't want to engage too much for fear of opening themselves up. But that communication between patient and practitioner is imperative to mitigation of claims. Doctors use really large words at the best of times, and those words and the actual experience of going to a practitioner where you're told you've got cancer and then they're using these big words that you don't understand, all of these things can add up to potentially affecting the claims ratios of a client. So in summary, electronic note keeping is imperative. Ensuring that your documentation is up to speed, you take informed consent, and you communicate clearly and concisely with your practitioner or with your patients at least. And then the final one, if I were to leave you with something, is the adoption of technology. Wherever possible, technology is advancing at rapid rates. Rely on the technology to assist you with decision making within your practice.
Well, thank you so much. I think on a last one, and it's a twofold question.
Yep.
Firstly, why have a local partner? And RJ, you're welcome to jump in here as well. Why have a local partner? And secondly, why Genoa? Elevator pitch.
Yeah, so I think for me, with IndemniMed, one of our core values is making it personal, and we associate with Genoa in that regard. I think they make it very personal in terms of their service offering to us as brokers. They do detailed underwriting. They go the extra mile in terms of finding the balance between adequate cover and affordable premiums. So that's one thing for me why we prefer Genoa. Also track record, their reinsurers, Sapphire. I mean, it's all highly respectable insurers. So yeah, for me that's two major focus points is that. And then I also think their space within the legal environment is something that we enjoy sharing with clients, and I believe maybe MJ or Ingo can maybe go in more detail with that. But I believe Genoa has a proper footprint within the legal space in terms of having clients and those same lawyers being on their panel to represent doctors. So that's a big focus point for us. Yeah, so other than that, they're very competitive in offering. It's an easy sell. So yeah.
Yeah, I mean, from my perspective, if I were just to add some points to that, when we brought the medical malpractice solution to South Africa, we did some very, very tough thinking around what are the actual needs of practitioners. Number one, they need to be represented by an incredibly strong legal bench strength. So in-house, we've got attorneys that are available 24/7. We've got medico-legal advisors. For example, Dr. Martin Brand, who's the head of Safe Surgery in South Africa and FOSAS, he is available via the Genoa 010 number to assist practitioners in their time of need. We've got Dr. Pete Anderson and a host of others that sit on that panel. We've invested heavily in CPD education of practitioners. So we have one of the most comprehensive CPD offerings available to our practitioners. And why do we do that? Because we believe that an informed practitioner represents a better risk. So I mentioned earlier that we'll guide them in terms of how informed consents work, or what is good bedside manner, or what are the potential pitfalls within practices. So that education is an area that we are heavily behind. As was mentioned earlier, Genoa is one of the few insurers in the country, or UMAs in the country, that are supported by Munich Re and Swiss Re. They are the two largest reinsurers in the world, and that capacity is essential because these claims come, and when they come, they are large. So you need to have that balance sheet and that backing of these guys. And I think that the solution, as is evidenced by the 6,800 practitioners in the country that have already taken up the Genoa solution, it is being well received by the market. And that's because, as I mentioned, we've done the thinking around what is the true value adds that those practitioners require.
MJ, Inga, RJ, thank you so much for sharing your expertise and for sharing, the knowledge that you imparted on the listeners today. I think if you are a first-time listener, please feel free to check out some of the other content, and also give us a thumbs up. Share this with colleagues and friends that is doing the transition into the private space, or that's working in government but needs some education and proper edification in this space. I also want to extend a friendly invite to check out these 2 episodes at the top of the screen. And until next time, remember to plan the plan.